All right, viewers, thank you very much. We are here for this very, very interesting live session. There are a lot of issues on tenancy matters. Landlords, tenants are claiming rights, and so many issues. In fact, you will be surprised the kind of questions and positions that tenants are taking. Last week, I was coming out of court, and then somebody started beckoning on me. Barrister, excuse me. I said, okay, what can I do for you? He said, I'm sorry to interrupt your day. I don't know you, you don't know me. But I have a question, sir. I thought it's a very reasonable question. I said, okay, sir, what's your question? He said, I have rented a property. Now the landlord has recovered his property from me. Court has enforced judgment and they have taken the property from me. Is there a way I can get court order to stop him from giving out the property to another person? Is this not witchcraft? You refuse to pay the landlord. Landlord has recovered property from you. Now you want to go to court and get an order to stop the landlord from putting another tenant in the house. How about now? So there are a lot of questions that people keep asking about the issue of tenancy. The landlord is asking questions, the tenants are asking questions. That is why we are taking the next 1 hour to tell you all that you need to know about tenancy matters. If you are a landlord, you can be here. If you are a tenant, you can be here. Your rent can be a residential apartment. You can be renting for office premises or any form of rentage. We carry out businesses in different locations and different premises. So today the channel is dedicated for this, and that is what we'll be discussing. To do justice to this topic, we have one of our seasoned legal practitioners, partner in the firm of Alabi and Sule and Associates, here a legal practitioner based in Abuja. Please do welcome Olatunde Alabi.
It's Joe.
Yes,
it's
thank
nice
you.
to be here.
Thank you very much.
Thank you very
We
much.
count it a privilege that you left your tight schedule to be here to attend to our pressing questions, pressing issues as far as the issue of tenancy is concerned. So please, we would like you to introduce yourself to our audience. This is the first time they were having you with us.
All right. So my name is Olatunde Alabi. I'm a legal practitioner. I'm based in Abuja, and I practice primarily in Abuja.
Thank you very much, Learned Counsel. We are sure you have had a lot of experiences with tenants, with landlords, recovery matters, and there are several kind of behaviors and questions you have seen over the years. He said, of course.
Of course.
So thank you very much. So to start with, we would like you to tell us about who a tenant is, who a landlord is, so that our audience will know which category they belong to.
Okay. So we'll try to make this as simple as possible.
Yes, please.
And try to avoid the legal terms so that people can, be able to relate with what we would say majorly. Now, a landlord is the owner of a property. In this case, a building could be for commercial use, could be for residential purpose, could be for whatever reason it is. But the owner, that's the person whose name is on the certificate of occupancy, is the landlord. Now, there are circumstances where someone else would be occupying the premises of another person for a particular period of time. That person is called the tenant because he has entered into a contract with the owner, which is the landlord, to use that property for a particular purpose for a period of time. That is why the person is designated as the tenant. During that period, the person can enjoy the premises as if he or she is the owner of the house. So that's the difference between the both of them.
All right. Thank you very much, sir. So there is landlord, there is tenant.
Yes.
The landlord is the person who owns the property,
of course,
while the landlord is the tenant tenant is the person in occupation of that property at that time.
Precisely.
Okay, so can you tell us, how do people establish tenant-landlord relationship? Is there an entry point?
Okay, now practice a particular period of time. Oh, I would like to rent it for 6 months. I'd like to rent the house for a year. I'd like to rent the house for 3 months or 1 month, as the case may be. And then they go into this conversation, which is about the amount for the tenancy, and an agreement is reached based on the conversation between the landlord, who is the owner, and the tenant, who is intending to occupy the premises. So that's how they start off the relationship. And if they agree eventually, the tenant makes payments to the landlord directly or indirectly, and then he occupies the property for that period of time that they've agreed to do so.
Okay, this their agreement, is there need for them to reduce it into writing? Is there any document they do in that regard?
Okay, so over time, there has been and this and that and all, and we've had most of these things result into litigation, something that could have, and this writing is it shows.
Oh, thank you very much. And when it is reduced into writing, the document is called tenancy agreement. Learned Counsel said the tenancy agreement will contain the amount, the property, and description, everything.
There are rights accruing to both the tenant. They all have rights as far as this tenancy relationship is concerned, and they enjoy these rights from the beginning of the tenancy relationship. So many other rights, but of course, as we discuss and session, we will talk about those specific rights that draw out from the relationship between the both of them. But primarily, there is a quiet possession, there is a right to recovery of the property. I think we'll start off from there.
Right to quiet possession. Have you had something like that before? Probably you've been a tenant or a landlord for so many years, yet you have not had quiet possession. These are part of the salient things you'll be learning today in this session, because we have somebody who is an expert in this, somebody who has done this, has represented landlords, has represented tenants in the court, and you will have a lot to learn from him. He's not going to withhold any information from you. So drop your questions, send your comments, make sure you subscribe to the channel. You keep learning things from us every now and then. So, Learned Counsel, we have had instances where tenants complain that I am in this property for so many years, and then suddenly the landlord decides to increase
Reject.
my rent.
Yeah.
Can the landlord increase the rent at any time like that?
Okay, so with respect to increase, it's broken into two parts. First of all, we need to understand that the tenancy relationship runs from year to year. Most of the time in Nigeria, if you bring out 9, 10 tenants, 9 out of them will be paying for their houses annually every year. Some pay monthly, some pay bi-monthly, some pay quarterly or 6 months per tenancy. Most of the time, it is per year. Now, what it means is at the point when you pay for your rent or you renew your tenancy agreement, you have renewed it for another 1 year based on your agreement with the landlord as the tenant. Now, there's something expected which is called reasonable time. You say that in law. It looks like a very simple English, but it has its own implication in law. Reasonable time. For instance, if a rent is running from January to December, and a landlord intends to increase the rent sum, maybe towards the month of August, September, is expected to notify the tenants, oh, we are enjoying this tenancy relationship from January to December. Our subsequent one, if you will, or if you still want to stay in my property, I would like us to renegotiate the terms from maybe 200,000 naira to 250,000 naira or 300,000 naira or even 150,000 naira if the landlord wills, because some landlords can reduce, but that is difficult to come by.
I wish it's still happening.
No, some landlords actually reduced, especially during COVID. Some landlords did that, and it was an interesting thing to see. But the landlord should be in communication with the tenants before such increase the rent. So it is expected for you to communicate to the tenant as the landlord within reasonable time to, I need to increase this rent. And in circumstances where the tenant feels, oh, I can't pay this increased rent, then the tenant can decide on what to do, like maybe, vacate the premises, get another cheaper apartment, or even negotiate for a lesser term than what the landlord has proposed. So these things are open. And I must state emphatically that the landlord does not have that unilateral power to just say, I want to increase rent, and that's it. There must be a conversation before a decision is reached. And where no decision is reached, of course, they can just, go their separate ways. It's not by force that they would be in a relationship for life.
Oh, whoa, whoa. So if I get what you are saying is that the landlord can increase the rent,
Yes, the landlord can do
but
so.
the landlord should be in communication with the tenant.
Exactly.
And it's not just as your rent is expiring yesterday, today this rent is not 200,000 again. This rent
Precisely.
is now 500,000. You either
Precisely.
pay or you
Or,
leave.
or you
For
move.
cordial relationship, at least communicate to your tenant long before time.
Yes.
Can the tenant insist that this rent will not be increased and I will stay in the apartment?
The tenants cannot do that. Now, the only time the tenants can do that is a circumstance where they agreed, for instance, that the rent will be 500,000 naira from January to December. I'll use January to December as example most of the time because it's easy to relate to. Let's say the tenants paid the sum of 500,000 naira for January to December. And in the course of the year, that's the tenancy duration running, maybe in March, the landlord now comes up to say, the way things are going in this country, that 500,000 I collected from me in January, I don't think is what is happening. So I'm going to increase the money in a tenancy that has commenced. I must state that that is inappropriate. So the tenant can insist in that circumstance that he or she is not paying the increased rent in this scenario that I just paid because the tenancy has commenced, an agreement was reached. But in the circumstance where the rent has expired or the landlord has notified the tenant within reasonable time before the expiration of the rent, the tenant cannot insist on the amount that should be paid because it is not your property and the initial contract has ended. So there is a room for conversation about what the new tenancy should be. So if you feel you cannot afford the rent, the nice thing to do is for you to vacate the premises so that you meet another landlord that would agree with you. It's a very auxiliary system. So all we need to do is just have a civil conversation and do the right thing.
All right, thank you
Yes.
very much. Then another thing we would like to ask is what of a situation where the tenant has paid for 5 years?
Yes.
Now, if you have paid for 5 years, can that rent be reviewed within the period of that 5 years?
Okay.
That is to say, I've agreed that I'm taking this possession of property for 5 years at
Yes.
500,000. After paying for the third year, can the landlord come and say, no, I'm reneging on my agreement, you are paying higher?
Okay, so now this brings us to whether there was an agreement, a tenancy agreement drafted, and all the terms and conditions were inputted therein. Most of the time, this period of 5 years is referred to agreed that this rent sum would be 500,000 naira. The landlord cannot come up in between and increase the rent unless in that same agreement, there is a room for rent review in the course of the tenancy. So all these things, that's why we emphasize that there should be a tenancy agreement. So that once a person, if one of the parties, either the landlord or the tenant, begins to come up with an attitude that is not in line with what they started with, the other person can easily make reference to the tenancy agreement or the lease agreement and everything will be resolved.
Thank you very much. So it's not a matter of arbitrarily coming up to change the terms,
No,
to change all things. So thank you very much. Another thing we would like to, please don't forget to subscribe to the channel, hit the notification button, and we are ready to take on your questions, your comments. As you drop them, we'll respond to them. I tell you, this man is loaded. He is completely in grasp of all the laws that relates to tenancy matters. So feel free and send in your questions. More importantly, this session is free. Nobody is charging you shit.
Making reference to the easiest one to attribute to the landlord. Any repair that has to do with the structure of the building, the building itself, things that form the fundamental part of the building, like the roof, for instance, is meant to be repaired by the landlord expressly. Anything that has to do with the pillars of the house, the strongholds of the house are basically for the landlord. Anything that has to do with um, repairs that occasion from wear and tears of interiors of the house are meant to be fixed by the tenant. For instance, you are using a socket, the electrical socket in your house, for instance, and it gets burnt. You cannot call the landlord for that. Yeah. Now we just crossed the rainy season. A lot of people noticed that their roofs were leaking. When you discover that, you reach out to the landlord, and the landlord has a duty to fix the internal one. For instance, the electrical sockets are meant for the landlord to be fixed. Your door handles, from time to time, you use it and it wears out. It is your duty to fix it as a tenant. So those things are, are things that we ponder on it at times and we say, no, this one is supposed to be for landlord, this one is supposed to be for the tenants. But there are some, I'll just generalize it, structure and internal part of the building. But notwithstanding this principle also, if they agree in the tenancy agreement that every repair will be done by the landlord, then the repairs will be done by the landlord. If it is agreed that every repair will be done by the tenants, then it should be done by the tenants. So you see where the tenancy agreement comes in to avoid arguments when issues come up. Yeah.
Wow, interesting. One of the things I picked in most of your responses is you keep making reference to tenancy agreement,
Yes.
tenancy agreement. So if I were you, I would consider that for any form of tenancy I'm going into, tenancy agreement is necessary, is very important. It stipulates the relationship between you and the landlord. It's very interesting to quote one of the statements he made after stipulating the rights for tenants and landlord. He said, notwithstanding all this, if your tenancy agreement says otherwise, you will do well with that tenancy agreement. Now, to come to very practical issues, you said major structures repairs will be done by the landlord.
Yes.
We are in a terrible time now, and the case of robbery is very common.
Yeah.
Now, if I am in a rented apartment and the fence fell off or the gate is pulled out and all that, which makes me vulnerable to robbery,
Yes.
and then I reach out to my landlord, and the landlord is either dragging his feet or comes up with the practical complaint, I don't have money at the time. What should I do? How should a tenant treat such a situation?
Okay. So usually, it is even advised that a landlord gives his property to a lawyer or a managing company to manage. Most of the time, I personally do not advise that tenants and landlords should interface with themselves. It's a foundation for so many issues and rifts. Now, when you communicate with the managing company or the lawyers managing the property, for instance, they would understand better than when you meet the landlord who might not be in a good state as at the point you would, but the mode of presentation might just be with respect to the house properly. Now, to come particularly to the issue of whether you should fix the property when you are open to a lot of dangers, like maybe the fence has fallen off and then you are exposed to, robbery and petty thefts in the community. I would advise for any tenant that is in such a situation to please try as much as they can to reach out to the managing company or the landlord if they have that access and then request for these things via a letter. Importantly, via a letter, via a means that you can use to prove that, oh, I tried to reach out when this thing was happening. And then, of course, if you go ahead to do that kind of fixing, for instance, your fence that falls off to protect yourself, you can lay a claim to the finances that you used to protect yourself in the person's house. It is not a problem because you did it to safeguard yourself and your property. So you
Okay.
can lay a claim to that from the landlord. But in a circumstance where you feel like, oh, this fence is not fancy enough, and then you want to bring some gold platings from Dubai to decorate the fence, you're liable for that. and you can't claim that from the landlord because it is not an essential upgrade of the property. So when you do it for your convenience, no problem. But when you do it because you want to, satisfy your luxury and your taste, then you might not be able to lay a claim to it.
Okay.
Yeah.
Thank you very much. If there are structural defects that becomes necessary for you to take step and you decide to take that step, what our learned brothers said is first communicate the step you want to take, and very importantly, communicate this step in writing. Make sure you have communicated to your landlord this is the situation of the property, and if you cannot immediately come to the help or to the rescue of the situation, I'm going to take this step, and then after that find a way of recovering my resources, right?
Very well.
You can either push it to the next year's rent or deduct from your rent or anyhow, but make sure you communicate to your landlord. And another thing is, you cannot lay claim of your luxurious upgrade on the property. You cannot push it to the landlord. You want to change the color of the fence, you want gold plate, like you said, you want to import gold from Dubai and all that, and you say the landlord has to pay. No.
Nah.
Now, there are situations because of the pressure in getting accommodations.
Yeah.
Some people sometimes rent an apartment that is not completed.
Oh, very well.
And at times, they even take the step to complete the building
Exactly.
and then rent the property. Or however the arrangement is, I don't know how they start, but there have been a lot of cases like this.
Yes.
What will be your advice to tenants in this situation?
Okay. So one of the first problems associated with this kind of situation is the commencement of the tenancy. Most of the time, the issue as to commencement comes in. And the tenant will tell you, oh, when I paid for the house was not ready. So my rent will start counting when I moved into the property. The landlord will tell you, when you paid for the house, I gave you the house already and you saw it was not complete. You are the one that choose not to enter. In fact, you even hear some tenant tell you, even if it's not completed, I want to enter because of the difficulty in getting housing and at times, just major Nigerian and general economic issues, people find themselves in that trap. I usually advise that it is not a good thing to do. Do not pay for a house that is not complete. It's a foundation for so many issues. You begin to say, oh, this socket, this window is supposed to be here, but it is not here. This is supposed to be here, but it is not here. Then the landlord begins to tell you, oh, no, I'm not supposed to do that. The ideal thing to do is to go and inspect a property, look at the property, negotiate for the tenancy rate based on what you have seen. You pay for what you have seen, not what you imagine in your head or what the landlord says will come. And then when you pay, you know that, oh, you've confirmed that this is what you want, then the tenancy relationship begins. So that's why I advise, do not pay for a property that is incomplete. It's a foundation for many issues. So if you really, I would not still advise. I might want to advise that sometimes if the circumstances are very there and it's so different, I might advise, but the bulk of the time, I would say do not pay for an apartment that is not ready. It's a foundation for many issues. So please try not to do that.
Okay, so we've gotten you on that. Now,
Okay.
what of our viewers who have already taken that step? Some people go to the extent of, okay, uh, this is the property, what is left is the painting, this and that, but I don't have resources to complete.
Yes.
Give me 2 months. When I finish the property, you can come and rent it.
Yes.
And then because this person's rent is expiring in 2 weeks, and he said, let's calculate the cost.
Yes.
I want to do it and move in.
Yes.
Now, what will be this outcome for such a person? What steps will they take to protect themselves if they have come to this agreement with the landlord? That, okay, fine, if you insist and you are desperate and you can't wait for me,
Yes.
complete it and enter the property. And indeed, the tenant is desperate. What
Yes.
steps should he take before
Yes.
doing that?
So if you have 500,000 naira, for instance, you want to rent, and then the landlord incomplete. And the landlord says, oh, I still need 50,000 naira, 100,000 naira to complete a particular portion of the house before you can move in. And the tenant says, oh, I have the house, I have the money rather, and I can use it while I can use 100,000 naira. I pay you 400. It is deemed as if I paid you 500, and then I move into the property. What you must do is to reduce that agreement into writing. Please, please, and please, always reduce it into writing. Because if you do not, it will be my word against your word. And when anybody goes to check your account statements or receipt of payments or whatever you are issued, it is showing that you paid 400,000 naira instead of 500,000 naira, as the case may be. So the landlord might have a stronger argument more than you, because the only evidence before anybody is that you paid what you paid. So please reduce it into writing. It is really, really, really important that you do so.
In whatever you do, make sure there is evidence.
There is evidence.
Make sure there is evidence. Make sure there is
You
proof.
know, like the popular saying online on Twitter, they say you explain, no evidence.
Go explain tire.
Explain tire. So make sure that when you are explaining, there is evidence to support what you are explaining. Yeah. So
Don't put yourself in a situation where you will have to explain and get tired of explaining, yet there is nothing to back it up.
yeah.
So we are still on with this session, and like I always said, don't forget to subscribe to the channel. Don't forget to give us a thumbs up, share this video. A lot of people out there need to get this information across to them. We're giving you this information for free because we at ISHAKU Legal Hub and all our legal partners are committed to educating you, to bringing interesting topics to ensure that you are enlightened. You know you are educated. We are trying to help you to become learned a bit. Just stay tuned with us. Now, there are so many issues with regards to recovery of premises.
Yeah.
We talk about notices, we talk about enforcing and all that. So we want to take this gradually and step by step. What are the instances or grounds upon which the landlord can decide to recover his premises from the tenant?
Okay. One of the grounds which is open to the landlord is if the property is used for a different purpose from what was rented to the person. Now we are in Abuja here, and of course there is Wike, who is our new minister, who is the champion of revoking CFO if you misbehave. Now start from talking about this. I spoke earlier that the landlord is the owner of the property, and because he's issued a C of O. Now, if you look at a certificate of occupancy, the purpose for the land is expressly written on it. If you buy a land, for instance, they tell you this land is for residential purpose, this land is for commercial purpose. Some are even very lucky and they get a land that is miscellaneous. That means you can use it for anything. But let's work with an instance. A land issued to a particular landlord who is the owner of the property is for residential purpose, and he rents it out to you to live in with your family. And then you decide to convert it to a commercial use, turn it to a supermarket. That the tenant is using the land for a purpose other than what it was rented to him or her, he can decide to recover property even before the expiration of the tenancy.
Wow.
I rent it to you in January. It's supposed to expire in December. In February, I discovered you are using it for something other than what I rented it to you. I can approach the courts to recover my property for you. It's that serious. So in these are one of the circumstances where the landlord can decide, I want my property back. So it's there are many of them also, but this
Change
one
of purpose.
yes, change of purpose.
Premises is rented to you as a residential apartment, and then you have decided because people are making a hell lot of cash out on shawarma joints, fast food joints, and you decide to change the purpose. The premises is rented to you for commercial, for residential purpose, and then you change it to commercial purpose.
Precisely.
The landlord will expressly have a right to recover his possession.
Yeah.
This is because if he doesn't do that, you're also putting his title at risk. All right. Thank you so much, sir. With that, are there other grounds, or could there be other conditions in the tenancy that the land tenant will not meet up to warrant eviction?
Well, if a tenant also decides to sublet the property, the landlord can decide to take over the property. Sublet, let me explain what
Thank
it
you.
means.
Thank you. Thank you.
Okay, what sublet means is I'm the landlord, you are the tenant.
Hmm.
I rent out my property to you. Sublet means you would now decide to be a landlord
Hmm.
again and rent it to someone else.
And rent it to Aremu.
And rent it to Aremu, for instance. When you rent it to Aremu, you have subletted the property. It comes from the main word, which is let. I let it to you. Then you sublet to someone else.
Please,
Who is
you'll
a
have
third
to explain
party.
this. Now, if I rent, I'm alone,
Yes,
and I decide to rent a three-bedroom apartment
yes,
for 1.5 million,
yes,
and here is Aremu, desperate.
yes.
Possibly Aremu just moved in from
And is
Lagos,
your friend or
and he's not
whatever.
even my friend. Somebody I can make something from. Aremu is not
Yes,
my friend.
yes,
And then I approach Aremu approached me to have either a room or two bedrooms. And because of his
yes,
desperation, he is willing to pay me 2 million. Guy,
yes.
is that nonsense?
It's a sense that will land you in serious. It's a sense that is nonsense, for real. So when you do that without the authority of the landlord, you have contravened the tenancy agreement. Unless, I'm going to make reference again, unless your tenancy agreement says that you are at liberty to sublet the property.
Oh,
But most of the time, you would never see a landlord that will agree to that kind of clause because it doesn't make sense. The landlord would rather rent his property to individuals and have a separate contract with everybody. So once you do that without the express consent of the landlord, you have subletted that apartment to someone else. You have made yourself a landlord in another person's property. And the landlord can decide to file an action against the tenant and even the co-tenant, who is now an occupier or a
at will.
busybody, occupier at will. So you can sue even if the landlord does not know the name or the designation of the other person, he can sue the person as a party that is unknown. So it's one of the grounds wherein the landlord can decide, I want my property back because it is a breach of the tenancy agreement.
So if I get you right now, if I want to rent an apartment,
Yes.
part of the due diligence I have to do is to know whether I am
Ensure,
renting from landlord or
yes,
from a co-tenant.
exactly. Or a
Because if
tenant turned landlord.
tenant turned landlord, because if I'm renting from a tenant turned landlord, I'm
Yes.
also at risk.
Yes, you are.
Interesting.
You are.
Do you know your landlord? Are you renting from a landlord or a tenant turned landlord? This is an assignment for you today so that tomorrow you will not hear yourself. Do you hear the word he used? That they can decide to call you an unknown person
Unknown.
or a busybody
Or
after
a meddlesome
paying
interloper.
meddlesome or interloper, after paying so much money
Yeah.
to an acclaimed landlord. So please, this is an assignment for you. Today, as you go back home, possibly you are watching this from your office or anywhere, make sure you know your landlord.
Yeah.
Make sure a tenant did not sublet where you are claiming that you have rented as an apartment, because there is danger for you in that sense. Now, there has been an interesting area that you hear people talk about all the time, this issue of notices. If my landlord wants me to leave his apartment, he has to give me 6 months notice because I'm a yearly tenant. Is there anything we need to know from you as a lawyer on this issue of notices and period that my landlord has to give me before I get
Pays his rent quarterly, that's 3 months, it should be issued 3 months notice. And then when a tenant pays his rent monthly or weekly, it should be issued 7 days notice. Now there's a drama that comes with all these things that are called notices, 6 months notice. In fact, recently I met a tenant that told me, barrister, I'm entitled to 6 months now. So let me enjoy my 6 months. Enjoy. Those were the exact words. Enjoy my 6 months. So in the mindset of many Nigerians, they believe that after they stayed from January to December, they can now stay from January to June.
End of June.
Yes, to the end of June of the following year. And then after that, they will now be satisfied that, I've enjoyed my 6 months. Let me now move out. Now, I'll tell you, the answer is yes and no to that kind of thing. You can enjoy the 6 months, quite all right. But what most of them don't know is for every second, every minute, every hour, and every day you spend in somebody's house, you are required to pay for it. So what happens is the law says that when the tenants are stayed for from January to December and is a yearly tenant, you have been paying your rent every year, and then the landlord decides at the end of that December that, oh, I want to evict this tenant. The landlord cannot push out the tenant just like that because this tenant is relaxed. Most of the time they have families, they have a lot of things they're dealing with, so you can't just tell them to go. They'll be stranded, and shelter is very fundamental. So what the law says is issue this person with a 6 months notice to exit the property. But what many people don't know is that you are going to pay for that 6 months pro rata. Let me use a simpler word. Pro rata means per day, per minute you stay. So if your rent is 1.2 million naira, for instance, 1.2 million naira, you pay yearly 1.2 million. If you stay for the 6 months notice, you are going to pay 600,000 naira at the expiration of that your 6 months, and then you evict, you exit the property. I need to emphasize this again. You are going to pay for the period of your notice. You will pay for the period of your notice. It is essential that you do that. Now, let me now move to another level of the gist. That 6 months tenancy that is issued also does not automatically mean that the landlord will come and push out the tenant at the expiration of the 6 months. The landlord is now required to approach the court to be able to evict these tenants from the property at the expiration of that 6 months. So then you go to the court, you tell the court your reason for approaching the court through your lawyers, and then you start the eviction process. And at the end of the day, judgment is given in your favor. And if the tenant persists and refuses to leave the property, then of course you can bring in the enforcement team to do the needful. So I must also state another twist to this, because Section 9 of the Recovery of Premises Act talks specifically about how the notices should be issued. What it says is, for instance, I'll use my usual example again. There's rent from January to December. And then in November, the landlord decides that he wants to evict these tenants, these yearly tenants. He cannot issue that 6 months in November. He can only issue it after 31st of December, which is January, so that the 6 months will be full. If the landlord wants the 6 months to terminate immediately the rent is expiring, he needs to issue the 6 months notice in between the 1 year tenancy, meaning you should issue it on the 1st of July in this circumstance, so that the 6 months will terminate on the 31st of December. In the circumstance where the 6 months cannot terminate on the 31st of December, then the landlord needs to wait to the expiration of the tenancy to issue the 6 months. It's quite, technical, but the law is the law, and there's no emotion with the law. But that's what it is. So that's the thing.
The law is the law. Don't expose your ignorance. Make sure you sit attentively. Make sure you listen. Make sure you learn. Now you can hit the notification button, subscribe to this channel, keep following us as we keep bringing you interesting topics to ensure that you are enlightened. Now, you made mention of the landlord has to go to court.
Yes.
On top of my property. What if I'm a military officer? What if I'm a senior police officer that I have boys under me that I can just deploy to you and throw the idiot out? What about that?
You can do that, but be ready to pay. Be ready to face the consequences.
Oh, so there's consequences.
Now, I'm going to say this on a very serious note. It is interesting to know that even in 2023, and even in Abuja, that is deemed to be so civilized, a lot of people still feel this is the way to go. We have some of our clients that, because the court process is slow, they tell you, but Barrister, there are things I can do to get this person out of my house. I'm just respecting you. You understand? And then we'll just tell them, no, just calm down. It's a wrong thing to do. You need to approach the court and do things properly. The essence of the Recovery of Premises Act is to curb the draconian behaviors of landlords in those days. I'll tell you something. I grew up in Lagos, and in Lagos, there are people who are called, in quotes now, this Egbon Adubo. You know what those people are called? Those people are like the chief, the big boys of the touts that don't stress, they don't shout. And all you need to do is, if you mobilize them, like you're mobilizing maybe enforcement or maybe court people, if you mobilize them, you can tell them that there is a tenant in your house and that tenant is giving you issues and you need to throw the person out. If you mobilize those boys, I saw those things growing up. If you mobilize them, they would go to the property, throw people's properties outside, and then you get your vacant possession. But a lot of people were not enlightened in those days, so they just suck it in and say, after all, I'm owing and my rent has expired, and they just move on with their lives. But there are serious consequences for that because you have trespassed into the tenant's apartment. Also, behaviors like going to remove the roof of your tenants because you feel, oh, if there's no roof, rain will fall, and they will feel very uncomfortable to leave, is totally unacceptable by the courts. If a tenant should report you as a landlord that you did something like that, you will not believe the consequences. Because apart from trespass, you could also be liable for a lot of criminal wrongdoings. So it is not advisable to use your military powers, your police powers, or your own physical powers, or your advantage of knowing area boys and touts to evict a tenant. Consult your lawyer, let them guide you properly, so that you do things properly and do things the right way.
Consult your lawyer and make sure you do things the right way. You can actually be sued over your property if you are reckless in the step you are taking to recover possession. There is nothing like resorting to self-help. Self-help is not allowed as far as the recovery of premises is concerned. You have rented out your premises, there is law that regulates that, and you cannot decide on your own to take the measure you have decided single-handedly to recover your possession. It has to go through the same process of the law. Very, very interesting. Now we have a question from Onifade. They said, what of the situation where you are a tenant into a property that is inherited? Okay, let me just read it straight. In case of an inherited property with various landlords, who who do we hold responsible as the main property owner? Mr. A has 5 children and then he died. After his demise, you are already his tenant before his demise.
Yes.
So who will now be your landlord?
The main
I think
landlord.
this is the question. Who is now your landlord?
Okay, so this one we are going into property law already, and we are going into let me say will and the inheritance of property. But this thing, I know it happens in Lagos a lot.
Everywhere.
Because I know,
Because
well, I know
landlords die.
yes, I saw these things more in Lagos growing up, so I understand it more from the perspective of what they would do over there. Now, there are circumstances where the landlord is even alive, but his children are struggling the rent with him. But let's take his own example, for instance. You need to be sure of who has gotten the inheritance of the property before you pay your rent to anybody. Because when a person dies, it is expected that the property has moved to people who are his beneficiaries, that's those his children or his wives. You need to take extra effort to know who the real owner is. If you don't do that, you'll find yourself paying 5 brothers or 5 offsprings, uh, pay all of them rent. Because after you pay A, B will come and chase you out of the property. You'll settle down and C will come. So you need to try, upon the demise of your landlord, please try as much as you can to settle the issues regarding who your new landlord is. Unless, of course, you are in the mood to have like 5 or 10 landlords at the time, and then you can afford to pay all of them.
And another thing is we have situations where 2 or 3 people are contending ownership.
Yeah,
Like in this situation, if 2 siblings are fighting, A wants you to pay to him, B wants you to pay to him, another person also wants you to pay to him. What you will do is you will take a step to approach the court.
yeah,
Talk to your lawyer, he will tell you the exact procedure that will be
exactly.
done so that you invite the court to interpret for you who actually is your landlord and who are you going to pay to, so that just like he said, you don't end up paying 2 3 landlords. But anyway, you say inherited property. If you want to be so liberal to keep paying the children of the deceased, then why not? If not, consult your lawyer and he will tell you the appropriate thing to do.
Yeah,
Now, in rounding up,
yeah,
just like he said, we can't even treat the issue of landlord and tenants in 3 hours.
and it's
We're trying
difficult.
to do the much we can within the limited time we have. What will be, we are running out of time.
Okay.
What will be your closing advice to tenants and then to landlords?
Hmm. There are a long list of advices that I can give. So many, so many. Now, as a landlord, please try as much as you can to see your tenants as your partner, someone you are in contract with. I know that's quite difficult in this part of the world because the landlord always wants to be a lord. I don't know. Maybe it's from the word landlord, the
I don't know
Lord.
where we got it
I
from.
don't know. The Almighty of this house. Maybe that's where it comes from. But the person occupying your property is the landlord for the duration of the tenancy. So it's more like he has all the rights. And at the expiration of that period, it expires. Try to respect them, try to show them love, try to be as friendly as possible, and then watch them reciprocate that behavior back to you and take care of your property very well. Also, ultimately, please, as a landlord and as a owner of a property, give the management of that property to legal practitioners or property managers. It is essential. These people are professionals in taking care of properties. So please, it is advised that you meet them for regular advices and then hand over the property to them to manage. I know it's difficult. Some people feel they have all the knowledge and they know everything about property. What do you want to teach them? But if you want to retain that respect and peace of mind, do not interfere with your tenants. Let professionals do it for you. And then for tenants, we have given so many guides in the course of this session, things to do and things not to do. And I'll round it up by saying, please, as a tenant, don't be desperate to get a property. Do your due diligence. Try as much as you can to know the landlord. Try to find out the issues with the building. Try as much as you can to also involve a lawyer while you are trying to rent a property. You know, we emphasize that they should have a tenancy agreement. But when you see that tenancy agreement, try to also consult a lawyer to review it. A lot of people are so desperate that maybe they've been looking for a house for months, and once they see one, bring anything to me, let me sign. I just want the house. And then when issues come up, you see some hidden clauses here and there that would not make the issues end in your favor. So it is important that you take a look at your tenancy agreement, you review it with a lawyer, and then you take a decision as to going on with the tenancy or not. Ultimately, essentially, all I've said boils down to you having a guide, which is a legal practitioner that would direct you on the right thing to do. So please always do that, either you're a landlord or a tenant. Please do that.
Wow, wow, wow. Thank you so much for this enlightenment. Thank you for your time. You see, there are a lot of areas that we have not even touched. We have landlords barging into the property at any time. We have so many complaints, trespass, all manner of misconduct from the landlord and tenants that we are yet to cover because we are limited by time. But we make this opening for you. You can watch this video at any time. You can come into the section, drop into the comment section, drop your comment, drop your questions. who will do well to answer you. Thank you for having us again today, and we'll do this again same time next week. Till then, we'll see you by that time. Thank you so much, Lane.
Thank you for having me, Pastor Joe. It's always a pleasure.
Thank you so
It's always a
much.
pleasure to be here.
Bing, 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 bing. I hope that's what you
Live
need
session ended.
in